Hi everybody, it's Andy and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to go over another common myth about how California does divorces. Now the myth itself takes multiple different forms, but the basic idea, the common thread I guess, is that in California people think that in order to get a divorce, your soon-to-be ex-spouse has to consent, has to agree, has to sign papers or something. And that if he or she doesn't agree, they don't consent, they don't sign papers, then the divorce cannot happen and you are basically stuck in the marriage for the rest of your life. Is that a myth or is that true? Now, perhaps you can tell from the way that I phrased the question, it is a myth. There's a short version, a short answer version and a long answer version. The short answer version is that it is a myth. The cooperation, the consent, the signature of the other party is required depending on the type of case you have. And the longer answer is basically this. So if you have looked into divorces in California, if you have done research and stuff on them, perhaps you've seen the term default divorce, uncontested divorce. Contested divorce would be the opposite of an uncontested divorce. But those terms basically describe different paths or different routes. And they are routes from the beginning of the case to the end. Now, I don't know if any of you have ever thought of it this way, but the beginning of a case over here is basically the same for everybody. Like, it's the point at which the two halves of the couple have decided, hey, this relationship is beyond saving, I really need to get out, he or she is not who I thought they were, etc., etc. So the decision to divorce basically is made over here, and then at the surrounding it, I guess, are a lot of questions about how is property going to be divided, if there are children, how much child support should be, if there's spousal support, who should pay it, how much, all that stuff. Way down the road, however, over here, this is the point at which all of those questions have been answered. So in other words, child support at this point over here has been paid or is being paid. Visitation is happening. Property has been divided already, and the parties are single, and maybe one or both of them are dating other people. So basically, the beginning point over here and the end point over here are pretty much the same for everybody. The path to get from the beginning to the end over here, that is what varies for most people. So the thing is, the routes that I was talking about, the default route, the uncontested route, those are the ways to get from the beginning to the end. And depending on which route you're on, the consent, the cooperation, the signature of the other party may be required or may not be. So to give you a kind of an example, a default divorce case, if this is your situation, a default divorce case basically, the best analogy I can think of kind of off the top of my head is a forfeiture in a game, for example, like a sporting game. So let's say that it's a basketball game and your team shows up but the other team doesn't. So in that case, your team wins by forfeit because the other guys didn't bother to show up. That's kind of what happens in a default divorce. Like basically one spouse shows up, the other spouse chooses not to participate and is not present, I guess. There is one difference, I guess, between a default divorce as well as a forfeiture in sports. In a forfeiture, the basketball example I used a second ago, a basketball game, if the other team doesn't show up, you win by forfeiture. You don't have to do anything. In a divorce case, if the other spouse doesn't show up, like they don't file a response, they don't go to court, etc., your divorce is not automatic as a result, you don't win. You still have a lot of steps that you need to do in order to finish the divorce and actually be single again. These steps that are involved, however, that you have to do, if the other spouse isn't there to participate, those steps are actually much easier. There's a lot of potential complication that basically goes away when the other spouse's participation falls out of the picture. So I guess in summary then, in a default case, it is not necessary to get the other spouse's agreement, consent, signature, etc. If, however, you have an uncontested case, then it is something where you do need the other spouse's consent, you do need their signature, you do need their cooperation. Now that's actually not a big deal because uncontested, basically by definition means that you and the other spouse have agreed already. If this is your situation, perhaps you've heard of the term marital settlement agreement, MSA. That is very common to have in an uncontested case. An MSA basically is a document, a written document, that lists out all the components that, of the agreement that the parties have come to. If you are in an uncontested situation and let's say the other spouse changes their mind or they try to back out or something, is that a big deal? A lot of times people think that it is, and it's actually not. So the thing is, if you are in a uncontested situation, you're not stuck there. Like, you don't have to pick at the outset which one you want. You can float between the two, or actually between all three of them, really. So what's very common actually in the cases that I do is the parties at the beginning will fight about everything. They're very angry, they're very emotional. This is actually very common in cases just in divorce court generally. If you do that, as time goes on, people start to get tired, they start to, calmer, their emotions calm down. Then they realize, hey, it's not worth fighting about this. Why don't we compromise on this? You give me this, I'll give you this. I'll give you more of this, you give me more of that, and it's basically the same thing. So to go from contested to uncontested is very, very common. In my kind of experience, to go the other way is less common, but it's not uncommon. So imagine it's like 60% contested to uncontested. That happens 60% of the time. The reverse happens like 40% of the time. But each lawyer's experience is different. But my point is that you can hop between contested and uncontested depending on how your case basically goes. So that said, I will caution all of you on one kind of aspect, I guess, of going from uncontested to contested, is that if you go before the judge to have the judge or the court decide, things that you can't agree on, like child support, property division, that kind of thing, you can certainly do that. It's your right. You can go to court to have the judge decide anything. Be aware, I guess, that even though you think that you have a great case, the judge, there's oftentimes a good chance that the judge will not agree with you. Like, the judge will not see the facts as favorable to you as you see the facts for you. So if you can't agree on something, can you go to court? Sure, but be aware that the judge, there's always the risk that the judge will disagree with you, and you might end up with less than you would have had you just agreed to what the other side was offering. Or you might end up with more. There really is no way to tell. So it's sort of a hit or miss gamble kind of thing. So you just have to determine for yourself whether or not it's worth it to take that risk in your particular situation. So hopefully all of that made sense. The answer, again, to the myth of, your spouse, your soon-to-be ex-spouse has to consent in order for you to get a divorce, is that true? And the answer is no. It does depend on the type of case, the type of divorce case you have. But ultimately, you don't have to agree to something just because you don't want to. If you and your soon-to-be ex cannot agree, you can always take it, have the judge decide the case for you. But just keep in mind that there is a risk there that the judge could rule against you, or the judge might give you exactly what the other side is offering in the first place. So it's a big kind of waste of resources. So hopefully that made sense. This video is. I don't think it's that confusing, but go ahead and rewatch it if you found it to be confusing for some reason. This myth actually is fairly common. A lot of times people think that, she has to sign divorce papers, or he has to sign divorce papers, otherwise I'm stuck. Not the case. So again, hopefully that wasn't too confusing. Go ahead and like, share, subscribe, comment, all that nice stuff. And I will talk to you guys next time. Thanks.